The Deputy Leader of the Opposition, Honorable James Nomane, has stated that the motion of no confidence against Prime Minister James Marape will proceed, despite a proposed amendment to the Constitution aimed at delaying such motions. This follows recent decisions by the Supreme Court of Papua New Guinea. On March 4, 2025, the Supreme Court, in a decision made by a 5-judge bench, dismissed objections to the opposition's application, confirming that Honorable James Nomane, as the member for Chuav, has the right to question the constitutionality of Parliamentary Standing Order 165. The court ruled that the Deputy Leader of the Opposition can proceed with the case, challenging the current rules regarding VONC motions. The next day, March 5, 2025, the Supreme Court rejected Nomane's request for an interim injunction to stop the proposed amendment to Section 145 of the Constitution. This amendment, which would require an 18-month waiting period before a new no-confidence motion can be filed after one has been successfully passed, is seen as an attempt by the Prime Minister to shield himself until the 2027 general elections. The court refused to intervene, citing that it lacked jurisdiction to interfere with parliamentary proceedings. However, the court's decision also clarified that the proposed constitutional change would not affect any motions of no confidence already in progress. It would only apply to future motions, meaning that the VONC could still proceed as planned. Additionally, the court stated that the challenge could be pursued under Section 19 of the Constitution, which allows for special references, ensuring that the matter of the amendment remains under review.
People of Papua New Guinea, a brief update on the outcome of the Supreme Court proceedings this morning. Initially, after the vote of no confidence with the Grand Chief Sapita Ipatas as the nominee on the 27th of November 2024 was prevented from going onto the notice paper by the Private Business Committee and the Speaker of Parliament, I was aggrieved by this decision and subsequently took the matter to court, filing a Section 18 Supreme Court application. Now, from that, there's been certain developments. You would have noticed that yesterday, the Supreme Court, a 5-man bench comprising of the Chief Justice himself, Salika, Sir Gibbs Salika, Justice Derek Hudson, Justice David Canning, Justice Dinganke, and Justice Kariko, handed down a decision that dismissed all objections to competency on my Section 18 application. That means that the matter will proceed to court for trial on, as they announced this morning, on March the 14th. That's Friday, March the 14th. That is when the trial will proceed, where we have questioned the constitutionality of Standing Order 165 as it extends to Section 145 of the Constitution. So we are arguing that Parliament cannot regulate Section 145, which is a constitutional section on the vote of no confidence. So the Supreme Court has dismissed all objections to competency raised by the interveners, which in this case are the Attorney General, Honourable Pila Niningi, and the Speaker of Parliament, Honourable Job Pomad. So we will proceed to a full trial on Friday, the 14th of March. So today's decision was in reference to the interim injunction that we were seeking to prevent Parliament from deliberating on Section 145. Now, you're all aware of the decision. I will make a certain reference to key parts of the decision. The court refused my application on the grounds that the Supreme Court lacked jurisdiction, as it could not interfere with parliamentary proceedings, and in so doing, it enforced the separation of power espoused in Section 99 of the Constitution. In protecting the rights of members of Parliament to have freedom of speech, to debate, and to engage in parliamentary proceedings consistent with Section 115, subsection 2 of the Constitution, my interim injunction to prevent Parliament from deliberating on the proposed amendment to Section 145 was refused. However, it's very important to note that on paragraph 3 of the decision, on page 6, paragraph 3, The decision further states that the proposed amendment would have nil effect on the vote of no confidence, since the proposed constitutional amendment would operate prospectively, not retrospectively. Now, what does this mean? The difference between operating prospectively and retrospectively. That means that a motion of no confidence in the Prime Minister can be moved at any time, after which this proposed amendment, if it goes through, will kick in. In short, this proposed amendment will not start from the 12th of September 2024, when a vote of no confidence filed against the Prime Minister with the Honourable Rainbow Paita as the alternate Prime Minister failed. That means that this proposed amendment, if successful on the floor of Parliament, will only come into effect when the vote has been concluded. So that leaves the vote of no confidence and an opportunity to put forth a vote of no confidence at any time Parliament convenes open. So this veil of protection that was applied to protect this Prime Minister and the executive government no longer applies. This was a cogent part of the decision raised by the five-man bench of the Supreme Court this morning. Further, the Supreme Court ruled that the challenge could be made. The challenge to the proposed amendment to Section 145 of the Constitution could be made pursuant to a special reference under Section 19 of the Constitution. The good news is that there is a Section 19 reference already on foot. And the proposed Section 145 amendment to the Constitution by the executive government will be rendered sub judice and not allowed to be debated, deliberated, and discussed even on the floor of Parliament. So in short, we have not only filed a Section 18 Supreme Court application to recall Parliament for a vote of no confidence, we have also filed a Section 19 Supreme Court reference on the proposed Section 145 amendment, thus rendering this proposed amendment sub judice, because it is under a judge, before the courts, and Parliament cannot deliberate on this bill until the Supreme Court decides and makes a ruling on the constitutionality of the proposed amendment to Section 145. All this is done in the defense of the Constitution. The Constitution remains supreme, and it is incumbent on all members of Parliament to defend the Constitution for the national interest, for the good of the people of Papua New Guinea. And this opposition, as a very responsible opposition, is effectively doing that for the people of Papua New Guinea. Thank you. If you have any questions on this and anything else, I'm more than happy to answer. Section 145 of the Constitution is a very important constitutional provision for a vote of no confidence in the Prime Minister. Being a very important constitutional provision, it cannot be regulated by a standing order of Parliament, because the Constitution is supreme. So the argument that we've taken to court is that Standing Order 165 cannot regulate Section 145 of the Constitution because it is a standing order. It is beneath the Constitution. It cannot regulate Section 145. When the PBC, and it's on the Hansard in the Parliament, when they made the decision on the motion of no confidence filed by the opposition with the Grand Chief Sapita Ipatas as the nominee, they concluded in their decision on the Hansard that everything was in order, that the motion of no confidence was competent, that it was of national interest, and that it should proceed, but for Standing Order 165. That stopped the motion of no confidence from then going onto the notice paper, and then for the Speaker of Parliament to adjourn Parliament for 7 days, at which time all members of Parliament would come back to vote and move and debate on the motion of no confidence in the Prime Minister. This is how Section 145 regulates the whole process of a vote of no confidence. So in short, this never happened. When the acting Speaker of Parliament read out the decision of the Private Business Committee, who in effect usurped the powers of the Speaker by making that decision, and he stopped members of Parliament from moving the motion and from debating on the motion, that's when he breached the Constitution. Hence why we're in court, to recall Parliament for the vote of no confidence, because there's been a constitutional breach. Now, our friends in the government will argue that all this vote of no confidence is bringing so much instability to the country. Well, we have to ask ourselves, if the government, the executive government, with the Prime Minister, the Honourable James Marape, if they were effectively driving policy, if they were effectively running the country and managing the affairs of the nation, would we have all these litany of crises that we see before us? Law and order, FX, lack of employment, inflation, fuel crisis. The answer is simple: no, we wouldn't. The vote of no confidence is so important to keep the executive government to account. This is part of a thriving democracy. This is what we must all defend. You're only as good as the people around you, and only as good as the successful implementation of your policies. And we have seen a failure in policy implementation under the leadership of the Honourable James Marape. Hence why we are pushing for a vote of no confidence, because the people of Papua New Guinea deserve so much better than the raw deal that they are getting under this government and the leadership. We have to allow all members of Parliament to participate in voting and to vote for a Prime Minister. This is not the birthright of the member for Taripori, nor is it the birthright of any member of Parliament. We are all privileged to be here. So we have to be held to account at a higher level through this sort of constitutional provision, which allows for a vote of no confidence in the Prime Minister. So ladies and gentlemen, thank you for your time, and that's the update on the court proceedings and the vote of no confidence.